All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I'm here under special appearance and under duress to address this matter.
You can immediately tell he's new to this. Not only does he take nearly 3 minutes just to read his own manifesto, but he can't even pronounce the key terms correctly. It's not sui juris, it's sui juris, a Latin phrase meaning of one's own right. And ironically, the mispronunciation completely undermines the authority he's trying to project. When someone positions themselves as knowledgeable yet struggles with the very terminology central to their argument, it weakens credibility and signals inexperience, making the entire presentation feel more performative than informed.
I am the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
It's pretty clear this guy looks like he spent the night frantically Googling how to get out of jail free and is now awkwardly repeating the very first script he stumbled across. Someone genuinely knowledgeable in these so-called sui juris arguments wouldn't be fumbling through memorized lines, mixing up terminology, or delivering it like a nervous student reading the morning announcements. Instead of sounding confident and coherent, the delivery feels forced and secondhand, which only highlights the gap between the image of expertise he's trying to project and the reality of someone obviously out of their depth.
Okay, I'll enter a not guilty plea on your behalf. Sir, I have to go over a few things with you to make sure you understand them, okay? You're
Yeah.
charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree, I'm asking if you understand. And is that a yes?
Yeah, I understand.
Are you sure you even understand what you're saying? Because Judge Shackelford isn't a bridge, so the idea of standing under her authority already shows the argument collapsing under its own confusion. Moments like this make it clear that the logic behind these so-called sovereign citizen claims often seems better understood by observers than by the people trying to invoke them. With that, the first video really doesn't escalate any further. It simply ends with the judge calmly setting a new court date. Now we move on to the next hearing, this time featuring a sovsit we've seen before from Thurston County, Michael Valentine.
So, Mr. Valentine, to unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet. And they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
You have to wonder whether the higher bail might have something to do with the fact that he openly refuses to recognize Washington state law or the court's jurisdiction in the first place. Bail isn't a fixed entitlement. Someone can simply demand on cue. It's discretionary, determined case by case based on factors like risk of flight and public safety. The Eighth Amendment protects against excessive bail, but that protection exists to prevent unfair or punitive detention, not to guarantee release under any circumstances. Misunderstanding that distinction or deliberately ignoring it often leads to misplaced confidence in arguments that don't hold up once they meet the reality of how courts actually operate.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. You're
Yeah,
not
we got
waiting for
everything.
tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're 2 separate cases now.
All right.
Does that make sense?
Kind of, but not really. On paper, the argument might seem reasonable. You were initially granted unrestricted release. Your conditions only changed after picking up a second charge, and that charge was later dismissed, so in isolation. Restoring the original terms could appear logical, but court decisions don't happen in a vacuum. The state is already moving to refile that same charge that triggered the bond modification in the first place, and more importantly, while out on release, you demonstrated a clear disregard for the court's trust by repeatedly violating pre-trial conditions through continued illegal substance use. Even if the charge is temporarily dismissed, the pattern of noncompliance still gives the court legitimate grounds to maintain stricter conditions because pre-trial release is built on demonstrated reliability and repeated violations undermine the confidence required for more lenient terms.
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount to, because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm gonna set this it's going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending in the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it
Nature of
under
the cause.
admiralty jurisdiction or common law jurisdiction?
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a
That's what I'm
common
telling
law?
you.
Is
Nope,
it under
it's under
common law
RCW
or admiralty?
4661. It's under Washington
So-
state law.
Don't you
Washington
have the
state.
duty to make the nature and cause clear to me, ma'am?
I
Do I
have,
not have a right to know the nature of the cause?
yeah,
nature and
and I
cause?
have.
The only reason anyone even knows what the charges are is because the judge clearly laid them out on the record. A DUI from 2021 and a second DUI from 2023 that was initially filed, later dismissed, and is now being refiled, a matter you haven't even been arraigned on yet. Without that direct clarification, there would be nothing mysterious to decode or reinterpret. The information didn't come from hidden meanings or self-styled legal theories. It came plainly and transparently from the court itself, underscoring how straightforward the situation actually is when stripped of unnecessary complications.
And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested
that's what I've
a
told
bill
you
of
today.
I've requested a bill of particulars and I've requested the case transcript and I've gotten neither.
Yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction. You're in
I said
Thurston
a
County
case,
District Court.
I said I asked for a case transcript and a bill of, case
Okay.
transcript and a bill of particulars, and I still
Okay.
haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still haven't
so,
made clear the nature and cause of the charges, ma'am.
all right, well, I think I have. So you're to turn yourself in to Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking you
obligation to
to, I'm
be,
just asking you,
I
as
understand,
my
I've
right, is it
answered.
not my right to know the nature and cause of the charges?
I've answered you,
so-
Mr.
so which
Valentine.
one-
I'm not going to go in circles. You're in custody by Friday or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling, it's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not gonna honor your oath to
We're
uphold
done,
the
Mr.
Constitution?
Valentine. I'm honoring my oath and I've done exactly what I'm to do by state law and constitution.
You haven't made
simply
clear the
disagree.
nature, you haven't
We're
made
done,
clear the
Mr.
nature and cause of the
Valentine.
charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
So that brings us to the end of the video. He's been given two very clear options: either post the $10,000 bond and remain out of custody, or turn himself in by 3 p.m. the following day. Of course, there's always that unofficial third option that seems to exist only in Valentine's mind. Ignore both instructions and enjoy what little freedom remains until law enforcement inevitably serves a bench warrant. At this point, the path forward is straightforward, even if the choice isn't. Let me know what you think will happen next, and if you found this breakdown useful, make sure to like the video and share your thoughts below, because we'll continue following how this situation unfolds.